Hello friends, welcome to StudyIQ. Friends, if you have been reading the newspapers or watching the news, you must have come across a lot of hue and cry, a lot of debate in the parliament, in the mainstream media regarding the issue of proposed amendments to RTI Act 2005. So in the next few minutes, we are going to analyze as to what the issue really is and the reasons why the proposed amendments to the RTI rules have got many NGOs dealing in that area worried. Okay, so let's proceed ahead and see for ourselves as to what lies at the center of this controversy. See, on 31st of March 2017, a circular was uploaded on the DOPT website containing these proposed amendments to the rules of RTI Act 2005. So these rules are called RTI Rules 2017. Now, under these rules, 5 to 7 amendments have been proposed, ranging from the hike in the fee and, reducing the timeline, other things. But at the center of this controversy, there are just 2 amendments, which, NGOs are debating would endanger the life of RTI applicants in one way or the other, or would persuade him or, arm twist the RTI applicant to withdraw his application. So let us see what those 2 salient amendments are, which are at the center of controversy. The first amendment here is that an RTI applicant can withdraw his own application. That is the application which he filed with his own consent, with his own will. He is now enabled to withdraw his own application. And the second, controversial amendment that is sought to be brought about is that after the death of an RTI applicant, his application would stand withdrawn. That is to say, if any RTI applicant dies or if he is killed, then his application would not be taken to the logical conclusion and the information being sought under the RTI application would not be disclosed to either his family members or to the public in general. So the NGOs like Commonwealth Human Rights Initiative, they are apprehending that considering the events in the past, considering the victimization of RTI applicants, the whistleblowers in the past, these 2 salient provisions in the amended rules might be used to victimize the RTI applicants, the whistleblowers further. Now, to prove their stance, to understand it better, we need to have a look at the dark events in the history, the dark chapters in the history which led to such incidents of RTI applicants, of whistleblowers being killed or being harmed in one way or the other. So let us turn to one of the important, darkest chapters of the history related to RTI or related to the whistleblowing or, disclosing of information of malpractices in the government working. So friends, this incident that we just now had a look at was the incident of 2003. So let's turn to the incidents that are happening against RTI applicants, the whistleblowers today. So for that we take the help of, in Times of India report dated 20th of October 2016, which says that the death toll of those using the transparency law to target corruption and malpractices have gone up to 56. And in fact, there has been more than 311 instances of harassment of citizens, including murder, attacks and intimidation from the time the law came into force in 2005, according to an analysis by Delhi-based advocacy group Commonwealth Human Rights Initiative. So these numbers are only those numbers which are registered with the National Crime Records Bureau, an agency under the Ministry of Home Affairs. So we are only talking about the crimes in which FIRs, the first information reports, have been registered. We are not talking about the incidents which have happened but have not been recorded in the criminal record books, right? Now moving forward, let's first understand what RTI Act basically is. What is right to information? See, RTI is given to every, RTI is a fundamental right under Article 19 Clause 1 of the Constitution. Article 19 Clause 1 says that every citizen has the freedom of speech and expression. Now, to understand this plain vanilla reading in a better words, we need to take support of the Supreme Court judgment of 1976 in the case of Raj Narayan versus State of UP, in which the Supreme Court said that people cannot speak or express themselves unless they know about the functioning of the government, or unless they have the requisite information with them. So it is basically saying that in order for people to exercise their right to speak or express themselves in a better way, they need to be provided with the information. So Supreme Court in a way embedded the right to information of a citizen in his or her right to speak. So this Right to Information Act is read into the right to freedom of speech and expression of any individual. So this is a very important thing. Otherwise also, if we see here, like in a democracy, information is said to be the oxygen of a democracy. So India being the largest democracy, there has to be a effective right to information, right to seek information of every citizen. So moving forward with this expression of right to information, let us have a look at the proposed changes and try to understand them in a better way. These draft rules propose to permit the withdrawal of an appeal if an applicant makes a written request. Suppose if I am the RTI applicant, if I had made a request for seeking the information from any government body. Now tomorrow, if I want to withdraw this appeal, I can very well do this after these proposed rules comes into force, right? Now, the first thing that comes to my mind is, why would I withdraw my own appeal, which I filed with my own will, with my own sweet will or my own consent? Why would I seek to withdraw this appeal in the first place? Number one could be that I might have to incur more expenses, or I have to hire a lawyer under the to pursue my case further. So this could be one of the reasons, right? Otherwise, why would I withdraw my own RTI application until, of course, I am being harassed by some third party, by the vested interest? Disclosure of information might lead to some harm to that vested interest. Now, until and unless there is any danger to my life or threat to my life or physical existence, I would pursue this RTI application to its logical end. That is, I will seek the information, right? Because it is available to me free of cost. If charges are any issue, then we all know that charges that we have to pay are just peanuts, are just equal to peanuts. Okay. Now, the second amendment that is sought to be brought about is pending appeals proceedings will come to an end automatically with the death of an RTI appellant. Okay, let us see how. Suppose if I have filed an RTI application with the authorities, with the government authorities, and in case if I die tomorrow, or if I am eliminated, or if I am killed by the vested interest, the private contractor, or anybody for that matter, even the senior government officials, okay, in the police authorities or any other authority. So if they eliminate me, should my RTI application be withdrawn, considered to be withdrawn or closed thereof, or should it be taken to its logical conclusion? I am nobody, so let's take the example of Honorable Satyendra Dubey. Okay, he was working with National Highways Authority of India. He pursued his case to such an extent that he went on to write the letter to the then Honorable Prime Minister of India, that is Atal Bihari Vajpayee ji. He said that he suspects something fishy in the working of the NHAI. He suspected that, and before the inquiry could be initiated from the PMO, Prime Minister's office, he was eliminated by the vested interest, that is the mafia, the contractors who were involved with the NHAI. So under such circumstances, should his application, if he would have filed any RTI application, in that era there was no RTI for that matter, if he would have filed that RTI application, then should his RTI application be closed? Let us look at the next slide and see what Supreme Court has to say on this. See, in as recent as 2013, in Union of India versus Namit Sharma case, the Supreme Court recognized and accepted this CHRI's argument that RTI appeals and complaints are not in the nature of a dispute, civil or criminal in nature, where the rights of parties have to be decided. So what the Supreme Court essentially said is that, as in case of civil and criminal disputes where the two parties are involved face to face, one party is the victim and other party is the perpetrator. So under such cases, disputes stand foreclosed. The case is not pursued further in case one or the other party dies. Okay, but Supreme Court said that RTI appeals and complaints are not in the nature of dispute. So that essentially means that, as a logic, RTI appeal shall continue even after the death of the original applicant, right? Now friends, let us move ahead and have a look at the other salient provision of the RTI. See, there's one section called Section 4 Clause 2, which says that every public authority or every government department should provide as much information suo motu, that is on their own, to the public at regular intervals through various means of communication, including the internet, so that public need not resort to the use of RTI Act. Okay. What we are saying here is that in the era of internet, the ministries and the government departments, they should on their own upload the relevant information on their websites, rather than making the citizen depend on them, or making the citizen run from pillar to post by filing an RTI application or by resorting to such means. The information should be available to the citizen right at the click of the mouse, sitting at his home itself, right? So this is the power given under the RTI to the citizen. But regarding its implementation, the Chief Information Commissioners, from time to time, the changing ones, the new ones, they have said from time to time, they have reprimanded various government departments regarding the non-implementation of this act. That is, the proactive disclosure of information is not happening under the RTI Act Section 4 Clause 2. So we see the working of UPSC, Union Public Service Commission. We see that all the information is proactively uploaded, ranging from roll numbers, ranging from other details of the working, the selection criteria, and there are very many other state public service commissions whose working is quite transparent and open to the public scrutiny. But there are very many other state public service commissions whose functioning is not up to the mark. For example, had it been so proper, this Vyapam scam would not have occurred. Okay, you know what I'm talking about. The Vyapam scam, the recruitment scam in Madhya Pradesh, one of the biggest scams in the recruitment of the public functionaries. So this has occurred because of the fact that some of the functioning is not proper. Right, let's move forward. Now come to the Whistleblowers Act. Whistleblowers Act was recommended by 179th report of Indian Law Commission as far back as 2001. So this tragedy of 2003 that we had a look at, that is Satyendra Dubey's case, this occurred in 2003. Law Commission submitted its report in 2001. Had the Whistleblowers Protection Act been passed on time, this would not have occurred. An honest civil servant would not have laid his life in front of the demon of corruption. Now, what this 179th report recommended, it said that the identity of whistleblowers, ranging from down from the level of a peon in the government department, or a clerk for that matter, up to the level of anybody, as mighty as an IAS officer, we have got various examples, I don't want to name them. So they should not be victimized for disclosure of information, for their try to avert any big scam that is in the making in the government department. Okay, that is whistleblowing. This whistle is not about the whistles regarding we blow in buses or trains. This is regarding any government functionary who wishes to disclose the information so as to avoid any kind of scam from taking place in the government departments, in the internal functioning of the government departments. Okay, secondly, this recommendation was that this Whistleblowers Act should prevent them from being victimized for their role in exposing corruption and financial irregularities. What this basically means is that suppose any whistleblower's identity, if at all, comes to the limelight, okay, then he should be provided due police protection, so as to save him from any attack or any victimization, any sort of victimization. Or in case he is working in the same department in which the vested interest is found, or in which the senior officials are corrupt, he should be transferred immediately from that department to some safer posting, right? So this is the kind of protection that was envisaged under the 179th report of Law Commission 2001. See, friends, why are we discussing Whistleblowers Protection Act over here? This is called the transparency agenda of the government functioning. One thing is Lokpal, the other thing is Whistleblowers Protection Act, and the third thing is Right to Information Act. These are interrelated laws. If any of the law is passed individually, then what we are seeing is victimization of RTI activists. This will continue to happen until and unless there is Whistleblowers Protection Act. So for example, anybody who blows the whistle through RTI, or who discloses any scam happening in the government department through RTI, through filing an RTI application, then he will be victimized. He would be left open in the field. open in the jungle to mess with the contractors, to mess with the mafia, or to mess with any sort of vested interest. If, for example, for instance, let's see, this Whistleblowers Act is there, very well there, then the government will be bound to provide him the protection under the Whistleblowers Act. Similarly, if Lokpal is there, then Lokpal will also inquire in a fair and honest manner as to what kind of scam was in the making in that government department. So this is a transparency agenda. These three laws are package. If anything is taken out of this package and implemented individually, then this will lead to what we are already witnessing, the victimization and the killing of RTI activists. Now let's move forward. Let us have a look at this great man. His name is Ashish Chaturvedi. He is the whistleblower in the Vyapam scam case. So at the behest of the High Court, security has been provided to him, but he time and again faces the threats to his life from the vested interest. So far 26 deaths have happened. Approximately 26 to 40 deaths are said to have occurred because of this Vyapam scam. Now he says that attack on him is imminent. So such great people are there who are not bending in front of the vested interests. So they need to be provided adequate security. Now, if this proposed rule becomes the law at the center, most other states will make similar amendments, thereby unwittingly jeopardizing the life and safety of RTI users. So, from the academic point of view, if we see, I have given you sufficient points. We have even analyzed the Whistleblowers Act that has been passed by the Parliament, but is not notified yet. Until and unless it is notified, it will not come into effect and will not be protecting the life of the whistleblowers or the RTI activists. So I would like to close it with the quote of Ghalib. He says, "दे मुझको भी शिकायत की इजाजत है सितमगर, कुछ तुझको भी मजा मेरे आजार में आए." So I hope you get this and correlate this with the analysis that we have done. So I thank you guys for watching this video. Hope you like it, and if you genuinely like it, please share it with as many number of people as you can. Thank you. Have a nice time.